May it please the Court, Matt Danielson. I represent Mr. Turner in this matter, the appellant that rises out of a traffic accident between a motorcycle and an automobile in Hanover County that occurred on July 4th, 2010. There are 5 assignments of error, but they really boil down to one, and that is, was it appropriate for the Court to give an instruction on contributory negligence given the facts of this case? And it is the appellant's contention that it was not, that there was not more than a scintilla of evidence to point to any contributory negligence on the part of Mr. Turner. If the Court looks at the facts as the jury would have had them in this case, they would have had that there was a collision, no doubt about that. Mr. Turner was eastbound on Ashland Road. Mr. Perryman was westbound on Ashland Road. There is no dispute about that. Mr. Perryman turns left, crossing the east portion of the eastbound lane of Ashland Road, turning onto Greenwood Road. He admits that. There is no question that Mr. Perryman never saw Mr. Turner until after the collision. He could not point to any evidence of excessive speed or improper operation on the part of Mr. Turner. Mr. Turner's testimony is he's riding, he sees Mr. Perryman's SUV in the westbound lane, that it's in its lane about 50 yards away, and when he gets about 30 yards away, the SUV turns in front of him. Those are the facts that the jury had. And when you look at those facts, it is certainly the position of the appellant that one cannot come to the conclusion, or certainly there is no evidence to support, an instruction of contributory negligence. We have to ask upon which of those facts can you support an instruction. The answer is none. The instruction of contributory negligence really invited the jury to speculate, and quite frankly invited defense counsel to speculate, which they did in their...
Counsel, do the facts indicate whether Mr. Turner was able to brake?
Actually, they do. Mr. Turner, 1, testifies that he broke. 2, the officer testifies that there was a skid mark, and that skid mark was in Mr. Turner's lane. 3, Mr. Perryman admits in his testimony that prior to the collision he heard the chirping of brakes. So there's no question that Mr. Turner did take evasive action in order to try to avoid the collision. He just was not able to stop in time. The only facts that the appellee is able to point to try to justify this instruction is the fact that the damage to the Mr. Perryman's vehicle is to the rear of his vehicle, between the rear wheel and the bumper. And the fact that, depending on what you believe, that the SUV was taking up either 1/2 or 3/4 of the eastbound lane at the time of the collision. But if we were to say that justifies an instruction on contributory negligence, what we would be practically saying is that in any case, an instruction on contributory negligence should be given. Because in almost any case, anybody can point to something that you may have been able to do better. If we're going to argue that Mr. Turner should have swerved instead of broke, instead of applied his brakes, then does that mean if a plaintiff swerves and can't get around that we can argue that he should have applied his brakes as opposed to swerving? The question is, did he try to take evasive action? Yes, he did. But there's absolutely no objective evidence to point to say that would justify the instruction of contributory negligence. The appellee points to several cases in his brief to justify the giving of a contributory negligence instruction. But if you read each of those cases don't deal with instructions. They deal with instances in which the court took away the ability of the jury to make a decision on facts that were disputed. In fact, the case that he points to that he says is most telling in this case is the West versus Kritzer case. And that is a case in which the court granted contributory negligence as a matter of law. Or not contributory negligence as a matter of law, but in that case, the court decided for the jury that Mr. Kritzer, who was operating a truck, was not negligent in any way. And what the court looked at is said, no, a jury could have found that he was negligent. He admits the evidence pointed that he saw warning lights, he saw flashing lights that he admitted were an indication that there's a problem and he needs to keep a lookout. He sees a vehicle coming into his path and took absolutely no action whatsoever. Matter of fact, the court says he took no steps to respond to the situation. And in that instance, they said it was error for the court to take the issue out of the jury's hands. Didn't deal with an instruction. But it is somewhat telling in this case, we don't have that. Mr. Turner did take steps. He broke. We know that from the evidence. Given all of the evidence taken as a whole, we do not believe that a contributory negligence instruction was appropriate. I would be disingenuous to sit here and argue to the court that a reasonable jury couldn't have come to the conclusion that Mr. Perryman simply wasn't negligent. I couldn't sit here and argue that. But as we have in the, it's the Ring versus Pullman case, in which this court had found a contributory negligence instruction was erroneously given. We can't, and we don't have before us, knowledge as to whether the jury made the decision of whether Mr. Perryman simply wasn't negligent or whether they relied on the erroneously given instruction to make a determination that he was contributory negligent. And therefore, the proper remedy is to remand this case for a new trial. Thank you.
Thank you.
May it please the Court, I'm Louis Kinser on behalf of Charles Perryman, the appellee. It is the contention of the appellee that negligence and contributory negligence were properly before the jury. That the contributory negligence instruction had much more than a scintilla of evidence to support its giving.
So what was that evidence?
The evidence was that Mr. Perryman applies his signal, slows down, is making a left turn onto Greenwood Road. At the time he does that, Mr. Perryman, he looks before he turns. There is no motorcyclist. There is no traffic in front of him.
That goes to the issue of negligence, not contributory.
Okay. What's the scintilla of evidence about Mr. Turner's negligence and the proximate cause of any such negligence?
And Mr. Perryman thereafter turns his vehicle. He is taking up a half or less of the lane. So the motorcyclist was not there when he turns, but we know from the photograph that the motorcyclist hits the very rear, between the right rear wheel well and the bumper of the vehicle that is taking up no more than half of the eastbound lane at the time of the collision. Why was that not, with the exercise of ordinary care and reasonable care, nothing extraordinary, why was that not arguably contributory negligence?
Let's talk about it, because the evidence in the case is that that's at the crest of the hill. And if you're westbound, you can't see the other lane eastbound. And if you're eastbound, you can't see the other lane westbound. That's in the record.
I believe the deputy said 5 to 10 car lengths, Your Honor.
Right. Well, 5 to 10 car lengths,
crest of the hill.
5 or 10 car lengths would be enough that if you were in that lane and you met somebody, you'd get hit.
Yes, sir.
Well, if you start from the center of a lane and you take the amount of space that you're talking about to the left of the SUV, that puts you out in the center of a lane. I mean, you're talking about him making some kind of a circus stunt to go around a car and to get to the other side. He has to go on an angle, according to your theory, to get into the other lane of traffic, and he doesn't know what's coming in the other lane of traffic.
No, he does not. He can stay within the lane, Justice Lemons.
I didn't read the record that way.
All right, and I am reading, if I may elaborate, sir.
Sure.
I am reading the record that Mr. Perryman has no idea where in the lane that the impact occurs. He has no idea. Mr. Turner. Mr. Perryman says that he has already committed to his turn and no more than half or less of his vehicle was still occupying the lane that the deputy sheriff says a tractor-trailer can pass through with no problem. He had adequate room to pass Mr. Perryman's vehicle.
It's that tractor-trailer that the motorcycle has to be worried about coming through on that other lane. It's the logging truck that goes to the mill down that's west of that location that he has to worry about going through that lane. And there's no evidence of speed in this case at all. Nobody, a speed limit. Nobody introduced the speed limit. Is that correct?
That's absolutely right.
So, we have a statement from Mr. Turner that he was going 40, and we have evidence that Mr. Turner saw the black SUV in the westbound lane, hadn't started turning yet, 50 yards away, and then saw him turn 30 yards away. So he's going 40 miles an hour. There's no indication that that's in excess of the speed limit. And he sees 30 yards away a car, a big SUV, that turns left right in front of him. And your evidence of contributory negligence is that he should have swerved with potentially the risk of going into the wrong lane.
My evidence of contributory negligence as being proper in the case is if the jury believed the part of the record Your Honor just read. If the jury believes that Mr. Perryman turned in front of Mr. Turner's motorcycle when it was 30 yards away, he was negligent. There is no doubt about that. If the jury believed Mr. Perryman that when he started his turn, which was his clear, unequivocal testimony, there was nothing blocked, there was no oncoming traffic, and he had already committed to 3/4 of his turn and had a half or less of his vehicle blocking the road.
He didn't say there was no oncoming traffic. He said he did not see Mr. Turner.
May I?
He said he didn't see Mr. Turner.
Excuse me, Your Honor. No traffic in either lane on page 42 and 60, Your Honor.
Which means he didn't see Mr. Turner because Mr. Turner was there. He ended up running into your client.
Barely, at the very end of the vehicle.
Well, there's also the testimony by Mr. Perryman that he says he saw two motorcycles approaching this road he was crossing over, and that he slowed his turn while this motorcycle was approaching him.
It was the other motorcycle.
I know, but he slowed down. He said he slowed down and came almost to a stop in making his turn while he's sitting in Mr. Turner's lane of travel.
While he's blocking.
So my question is, assuming that you're saying that Mr. Turner at that point, that there's evidence that he could have swerved and gotten around this?
And remained in his lane. Yes, Your Honor.
You were also arguing to this jury that he had only had a motorcycle for a short period of time.
Yes, Your Honor, I did.
So let's suggest if I buy a new car and I drive it off of the lot, you get to argue that I've only had that car for a short period of time?
I think with a vehicle, no, I don't, Your Honor. I think with a specialized vehicle such as a motorcycle, that the evidence was that the motorcyclist had only been licensed to operate a motor vehicle since 2008.
Well, that's great. So you get your license, and you get in an accident immediately after getting your license, and you're subject to a contributory negligence instruction because you've just gotten your license?
That is not a reason that I offered on either brief or in argument, or meant to offer on brief or argument, Your Honor. That was experience based upon his lack of experience on the motorcycle, and that was closing argument, which wasn't evidence, and it was based on his lack of skill and experience with the motorcycle.
So you made a closing argument that was not based upon the evidence?
I said closing argument is not evidence. It needs to be based upon evidence.
Well, surely you wouldn't argue something that wasn't in evidence, would you?
No, Your Honor.
So it must have been in evidence.
And it was, without objection.
Counsel, I'd like to take two of the facts that Justice Lemons based his question upon. 40 miles an hour and 30 feet. Now, 30 yards.
Yes.
Those are undisputed on the record, are they not? There is no contrary evidence to those.
Yes, there was, Your Honor. My client's testimony that when he began his turn, there was no oncoming traffic.
He didn't see any oncoming traffic. He cannot dispute whether Mr. Turner was 30 yards away. Is that correct?
No, he never saw him when he began his turn, so that is correct.
Okay, so that statement that I was 30 yards away is a fact for purposes of this case, is it not?
It is a fact, along with the fact of Mr. Perryman's testimony, that he slowed, he looked, he kept a proper lookout, and he made a left-hand turn, and there was no oncoming traffic.
We are permitted to take judicial notice of time distance tables. It takes 1.54 seconds to travel 30 yards at 40 miles an hour. I believe we also can take judicial notice that from the instant that one sees something ahead of him, that individual cannot react at the exact same instant. It takes some period of time to react, either by swerving or by braking. Your argument necessarily is that if one does not, over a period of 1.54 seconds, determine whether to brake or swerve, that is negligent?
I'm saying that is a jury issue as to whether it was negligent.
1.54 seconds.
And
that's negligence. That's what your argument boils down to. 1.54 seconds is what it takes to travel 30 yards at 40 miles an hour. And during that 1.54 seconds, I have to recognize what the danger is. I have to analyze what my alternatives are, and then I have to choose the right one. And if I don't do all three of those in 1.54 seconds, it just took me about 3 seconds to say that. If I don't do all three of those in 1.54 seconds, I'm negligent. That's what your argument ultimately is.
If the 1.5 seconds you're looking at a lane, your lane being occupied by a half or less of a vehicle, and you're on a motorcycle, is that reasonable? Is that exercising ordinary care?
But just a minute, you're assuming that amount of space was available the whole time. Your client, I hope, was continuing to move across, and so at the point of impact, there may have been that much, but there wouldn't have been that much space the entire 1.5, whatever it was, seconds.
He says he was moving at a crawl when he was hit.
But he was still moving.
Yes, barely. That's correct, Your Honor.
So as I understood the police officer's testimony, there was that much space at the point of impact, still in that lane of travel.
No one, neither Mr. Turner nor Mr. Perryman know, because Mr. Perryman has no idea where within that lane of travel the impact occurred. He does not know where his motorcycle, where Mr. Perryman's, the rear portion of Mr. Perryman's SUV was when he struck it. He does not know where in the lane it was struck. And I think that's significant. And I think it was a jury issue. We assert it was a jury issue as to whether or not he acted reasonably under the circumstances, not using extraordinary care, using ordinary care. And that the trial court, that there was more than a scintilla of evidence based on the circumstantial factors of where the impact occurred. Alone. Let alone Mr. Turner's testimony that before he made his turn, he looked and saw nothing.
Well, that's his negligence. We're not talking about your client's negligence here.
That would be primary negligence to begin with, except for the fact that it's in direct conflict to Mr. Turner's testimony that Mr. Perryman turned right in front of him when he was 30 yards away. That creates a jury issue right there on both primary negligence and contributory negligence.
How does that create an issue as to Mr. Turner's negligence?
How
does that create an issue of Mr. Turner's negligence that your client turned right in front of him?
But he says he did not. He had already made his turn, and he'd already come almost to a stop because of approaching motorcyclists from Greenwood Road that he thought was going to go into his lane. Then he was struck. And that's 4 to 5 seconds. That's not the one that is in the record, and that is Mr. Turner's estimate. and not 1.5 seconds. So there was adequate. We do not have perfect time and distance measurements. We do not know where the skid marks were in the roadway in relation to the point of impact. We do not know in what portion of the lane the point of impact occurred, and we do not know how much of the lane was open for Mr. Turner when he made impact with a vehicle.
Sounds to me like you're making an argument that the absence of evidence constitutes the scintilla of evidence that's necessary to have a jury instruction.
Not the absence of evidence, but we're entitled to any inferences and circumstantial evidence, Your Honor.
From the absence of evidence.
In terms of primary negligence, you are.
Yes, sir.
But that's not the assignment of error. Assignment of error is contributory negligence.
I understand. And on the nature of the roadway, the 3 to 4 second estimate of Mr. Turner and the point of impact and my client's testimony that he was blocking no more and probably less than half a travel lane at the time he was struck should have entitled us to a contributory negligence instruction. Thank you.
Thank you. Rebuttal?
Thank you, Your Honor. If any members of the court have any additional questions, I'll be happy to address them. Otherwise, I have no further argument.
Well, let me just ask you one.
Yes, sir.
Do you and opposing counsel agree to the numbers of the various instructions? I can't find instructions with number 2 and 13 and all. Is there any dispute that they are accurately reflected in your briefs?
Your Honor, I'm not quite sure if the court we numbered them and then the court rejected some and they weren't in. Is there a particular instruction that you were interested in addressing?
I can't find an instruction with numbers on them in the record. But if you all don't disagree that the ones you're contesting are numbered as you say, then that satisfies you.
Yes, sir, and certainly worded the way that we've indicated in the record. Yes, sir.
I agree, Your Honor.
Thank you.
Thank you very much.
Thank you.